That's all you have, right? You don't have anything else?
Jemison.
That one, but.
Okay, Mr. Moss,
Yes, good morning, Your Honor.
good morning, and you're with Heather Derrick.
Yes, I am, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Heather Derrick, file number 22-00194 FY. Council appearance, please.
Yes, good morning, Your Honor. Attorney Jackie Moss for and on behalf of my client, Ms. Derrick, who is seated in my office with me, and we consent to having this sentencing proceeding conducted via Zoom.
Today was the date that was set for a sentencing. I do have a pre-sentence report recommendation. Did you get that, Mr. Moss?
Yes, I did, Your Honor.
Okay, any reason to make any updates, corrections, or deletions?
No, Your Honor.
Okay,
Oh.
you can proceed to allocution.
Thank you, Your Honor. I'd like to just highlight a couple of things that appear in the recommendation. The fact that Ms. Derrick is classified as a low-risk individual with no prior criminal record. Based on my interactions with Ms. Derrick over the past several months, I can say that she is remorseful for her actions. Based on that, I would ask the court to please sentence Ms. Derrick in accordance with the plea agreement to no upfront jail and to follow the recommendation of the probation department of no probationary services necessary. Thank you, Your Honor.
Thank you. Did your client wish to make a statement?
Yes.
You can do so at this time, Ms. Derrick.
Good morning, Your Honor.
Good morning.
I just want to apologize to the court for my actions and for tying up the resources of the court because of my actions. After being sentenced to 5 days in jail in December and arrested on a warrant resulting in another night in jail in February, not being able to take care of my family, missing events of my children's lives, I have learned to verify evidence before presenting it to the judge. My actions of not checking the validity of the evidence has led us here today. I am not making an excuse for what I have done. It is in fact my mistake for which I apologize.
Thank you for that statement. I've had an opportunity to review the pre-sentence report and as well as your criminal history report, which there was nothing else there other than this incident. This is an unfortunate incident because false pretenses essentially arise out of the fact that there was some false information, or you presented some information that would cause you to not believe that you're a person who's trustworthy. And I don't believe that based on your criminal history and what the pre-sentence report states, that that's something that adequately characterizes the person that you actually are. So I think your statement is important and it's meaningful because it shows that you understand how your actions can impact your reputation and your integrity. You can't just present evidence or information to the court unless you know that it's accurate. This is not a situation where the court needs to put you on probation. I think that's indicated on the pre-sentence report. It's also requesting or suggesting that the court only issue monetary fines and costs, but I'm looking at your employment and your earnings monthly, and that doesn't appear to be in the court's best interest either, because doesn't sound like you make a lot of money, ma'am. I think what would be meaningful is for you to write a letter of apology, or it could just be that letter that you just stated there on the record for the file, and that information can be provided to the courts that you presented the false information to. Are you comfortable with putting that or providing the court a copy of the letter that you just read to us?
Absolutely.
I'll place it here in the file. You've already served some time in jail over this. I think that you've already experienced the gravity of the situation. I'm not going to impose any jail time in this matter. I'm also not going to put you on a term of probation. There is a $75 crime victim rights fee that will be assessed. I will waive any additional discretionary fines and costs. Okay?
Thank you, ma'am.
Thank you, Your
When
Honor.
you make payment, when can you make payment on the $75?
I can bring it in today.
Okay. Will you be bringing your a letter as well today?
I can, yes.
Okay, I'll note that here in the file. Do you have any questions for the court?
No, ma'am.
Any additional matters for the record, counsel?
Nothing for me, Your Honor. Thank you.
Thank you. You're all set, Ms. Derrick.
Thank you.
Everyone have a great weekend.
Same to you. Mr. Keithley and Justin Moore. Are we ready on the sentencing?
Yes, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Justin Deshaun Moore, file number 21-032661 FY. Counsel appearance, please.
Good morning, Your Honor. James Keithley, Assistant Public Defender, appearing on behalf of Justin Moore, who is present via Zoom.
Yes.
Okay, thank you. Today's date that's set for sentencing. I do have a pre-sentence report and recommendation. Did you receive a copy of that, Mr. Keithley?
I did, Your Honor. I had an opportunity to review it and go over it with Mr. Moore. We have no additions or corrections at this time.
Okay, proceed with your allocution.
Thank you, Your Honor. I've gone over the report and the recommendation with Mr. Moore. We would be asking that the court adopt the recommendation. It seems a fair recommendation. Mr. Moore doesn't deny wrongdoing here. He recognizes that he acted wrongfully and shouldn't have behaved in the way he did that brought him before the court. Fortunately, it doesn't seem to be a pattern of behavior for Mr. Moore. This is his first OWI type offense, as far as I'm aware, and it looks in the report as though there is some question as to whether Mr. Moore actually has a substance abuse issue. According to one metric, it appears he didn't meet the diagnostic criteria for a substance abuse disorder. However, according to another metric apparently used in the report, he had a high probability of having a substance abuse disorder. Based on that, I think that a term of probation that would have some alcohol and substance abuse education and testing to ensure that Mr. Moore is not using substances is appropriate. That would ensure public safety in terms of making sure that Mr. Moore is not using substances. Additionally, giving him the tools to ensure he doesn't come before the court on issues like this again in the future. So as I stated at the beginning, Your Honor, we would be asking that the court adopt the recommendation and sentence Mr. Moore as is listed in the report.
Thank you. And Mr. Keith, did your client wish to make a statement?
Mr. Moore, is there anything you would like to say to the court?
I'm just very sorry for wasting time coming back and forth, and I promise I won't be in front of you over issues like this again. I guarantee.
Thank you. I've had an opportunity to review the pre-sentence report, the recommendation of probation, and then your prior criminal history. As indicated by Mr. Kesey, this is your first offense of this kind. Originally, there was some concern about your ability or willingness to participate in the court order when you didn't appear to the first time to get your pre-sentence report done, but it sounds like that actions was remedied. You appeared timely on the second referral. And so the recommendation is for a relatively short time of probation, 6 months, and for you to submit to random testing and attend some and complete substance use education and follow any recommendations of the treatment provider. I think that is appropriate under the circumstances, and so I will adopt the recommendation. I will sentence you to 6 months probation. While on probation, there's a $30 per month oversight fee that you're responsible for, okay?
Yes.
Okay, you're not to use, purchase, or possess alcohol, marijuana, or any other controlled substance unless you have a valid prescription while you're on probation. Do you understand that?
Yes.
You're not to purchase or possess a firearm, ammunition, or weapon of any kind while on probation. Do you understand that?
Yes.
You're not to be at any bars or nightclubs. You're going to be required to submit to random preliminary breath tests and or your analysis testing. You are responsible for the fee associated with that, okay? Okay,
Yes.
can you hear me? Okay.
Yeah. I'm at
Thank
work
you.
a little
I'm gonna-
bit, so it's hard.
No problem. I'm going to order that you participate in substance use education.
Okay.
And provide verification of that to probation. You're also to follow any of the recommendations as it relates to any treatment, okay?
Okay.
Do you have any questions about your conditions as it relates to probation?
No, I don't.
Okay, as to fines and costs, there's a $75 crime victim rights fee that will be assessed, $50 state minimum cost that will be assessed,
Okay.
and that's on each count.
Okay.
On count one, you do owe $201.96 to the Lansing Police Department for responding to this incident. And then probation will be $180.
Okay.
So your total is $631.96.
All right.
You'll be able to make monthly payments on that, okay?
Okay, that's fine.
I'm also gonna order that you maintain your employment while on probation. There's an advice of rights for probation early discharge. It reads that you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights, sir. You have the right to request early discharge from probation once you have completed half the original term ordered by the judge. You may request early discharge from probation after meeting the following conditions. 1, you have completed all required probation programming, and 2, you have not violated probation within the 90 days preceding your request. If a hearing is scheduled to address your request, you would have the right to retain or hire an attorney to represent you for that hearing, but you would not have the right to court-appointed counsel if a hearing for early discharge is scheduled, okay? Lastly, the form that you would need to complete for early discharge requests is the MC 512 form, and that form is available on the court's website. Do you have any questions about that?
No, I do not.
Okay. Any additional matters for the record, counsel?
No, Your Honor,
Your
thank you.
Honor,
Yes.
Andrea Lacey appearing on behalf of the people, and I don't know if it's already been done, but the agreement was that upon successful plea and sentence, people would move to dismiss count 1. Obviously, he's already taken the plea, he's now been sentenced, so we're gonna move to dismiss count 1 if it has not been dismissed already. The original.
I'm inclined to believe it was already
Okay,
dismissed.
that's fair. I just wanted to make sure that nothing gets, it doesn't get missed on my part.
Okay. Yep, I had a note here on March 11th, dismiss count 1.
Okay, perfect. Thank you.
No problem. Any additional matters for the record?
No, Your Honor, thank you.
Thank you. You're all set, Mr. Moore.
Have a good weekend, Your Honor.
Same to you, Mr. Healy. Okay, here's that one. Mr. Sharps is here for Jameson. Who's Trice here? That's Donald's client. Are we running Jameson?
My understanding, you're going to be.
That's correct, Your Honor. Mr.
Oh.
Jameson's interested in waiting for examination. Thank you.
Okay, do they get put them on? Or do we have to bring them up? Yeah. Okay, sounds, yes, please. Okay, and Mr. Trice, can you hear me?
Yes,
On the record in the matter of the people of the state of Michigan versus Rashad Trice, file number 21-03410, counsel appearance, please.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of defendant Rashad Trice, who's appearing by Zoom from Livingston County Jail.
Okay, the court does have a pre-sentence report and recommendation. You received that, correct?
Yes, Your Honor.
Okay, the recommendation is that due to the fact that he has been incarcerated since August 2021 under a sentence in the 44th Circuit Court, expected to be released in November 2022, and starting a 24-month probation through Livingston County, it's not meaningful for him to do probation before this court. Court will issue a sentence credit time served. You can feel free, or your client can feel free to make any statement though that you would like to make.
No, Your Honor. Well, just that, I mean, you've already said some, the one issue though, I didn't want to leave it out there about the There were recommendations, probation reached out to the victim and he had requested some restitution, but they didn't get any further word from him, and I don't see him here, so at this time, I was just gonna request that he be sentenced with a restitution at 0 unless it's amended later. But other than that, Your Honor, I just wanted, I know you're already gonna send him on his way, but I have spent a lot of time talking to Mr. Trice over the last few weeks. Livingston County, they have 1 hour Zoom appointments, so we filled that time talking about what he wants, his hopes and dreams. He seems like he's grown up a lot recently. He's had to grow up a lot recently here, Your Honor, and but he regrets his actions, and I appreciate his outlook on life. That he seems very hopeful. He's got a son now. He wants to be in his life. He's learning things, and in jail we talked about how he's doing in there, and so I just have a lot of hope for him, and I wish him the best. Thank you, Your Honor.
Thank you, Mr. Trice. Did you want to make a statement at all?
Yes, Your Honor.
Feel free at this time.
I would like to thank you for giving me the time to solve this matter, and now I can put everything beside me, and also just be there for my child when I come home and look for better things in life. Thank you, Your Honor, for letting me speak.
Thank you, and I am hopeful that this time that you have in Livingston County will be time that you reflect and that you come out and you're ready to be a better person, that you're prepared to become a productive member of society. So good luck to you, sir. As to the issue of restitution, I've not received anything regarding restitution. I'll let the prosecutor put appearance on the record if there's anything that I missed, but because there's something noted on the judgment of stating there should have been $129 restitution, but I don't have any record of that.
Your Honor, Andrea Lacey appearing on behalf of the people, and the only thing I have is victim impact statement, and that is the amount being requested. I don't have anything in terms of receipts or whatnot. I'll reach out to the victim and see if we can get that to the court and have it amended to include it.
Okay, so no restitution will be ordered at this time. 93 days Ingham County Jail credit time served. You're all set for now, Mr. Trice, okay?
Thank you, Your Honor.
Thank you. Have a good one. Mr. Rothstein. Have you seen Ms. Schaub at all?
I have not, Your Honor, and I checked yesterday and we checked again this morning. She doesn't seem to be in any juvenile state.
I think you did file 2 motions here.
I did, Your Honor.
Okay, I'll grant both the motions.
Thank you, Your Honor.
I'm sorry. I think one of them's already in bench warrant status. She's not in bench warrant status on a 21 file, so you can do one for that one.
Thank you, Your Honor.
Thank you. Is y'all gonna do it? Put them on or we have to put them else? Oh, Emil Moore. Mr. Moore, do you have an attorney? I'm sorry?
I had perfect time to get proof of my non-employment. I told him, I said, call DHS and they'll verify everything for me. And shit like, well, you can't go do it, then we can't help you, this, that. I said, what I gotta do is you like, go down there and set up an appointment and get the paperwork and bring it down to us. I said, well, I got court appointment on my other case for my driving. I said, how am I not getting a court appointment for this? I'm going to.
Did you provide them the verification they needed?
They just called me yesterday for it.
Okay,
So I had to call down there, set up an appointment, and they called me at 4 o'clock to tell me that.
so you still gotta get some documents to provide them?
Yep, they want me to go down there and get documents. Bring it down, but my other case, they down there, court appointment. And all they did was call down there. And that's what she said. Why did they call down there? Just to verify it, put it right in there. I don't know. They want me to do all this. And it's just a simple situation. When we first get recorded, all we get dismissed.
Okay, who is your court appointed counsel on your other matter?
I don't know. They just gave it to me. She gave it to me this week. Or this week.
Oh, so you were just appointed court appointed counsel on one matter, but not on this one?
Yeah. I don't understand. They just give me a court appointment. They all get dismissed. the first day of
Listen,
court.
I don't wanna hear about what you think is gonna happen, okay? Because you don't know what's gonna happen. That's what you want to happen. I don't want you to get into details because you have the right to remain silent. You may say something that could be used against you. My concern, though, is that you have another case pending for licensing, you said?
Yeah.
And they just appointed court appointed counsel? But then, okay. I'm gonna see if someone could look into this for you, because that doesn't make any sense. Mr. Starks, we have the jail here.
My apologies, Your Honor.
Oh, the jail is here now.
Okay, great. Yeah.
If you can have a seat there, sir, what I'm gonna do is I'm gonna have one of these public defenders try to see if they can figure out what's going on or what is needed, because I don't see how you can need something on one file and not need it on the other, but get appointed. Doesn't make sense to me. Okay. We're on the record, there, you're Mr., oh, this is Mr. Jameson.
Yeah.
Okay, we're on the record in the matter of the people of the state of Michigan versus Walter Jameson, file number 21-02405 FY, council appearance.
Good morning, Your Honor. Andrew Lacey appearing on behalf of the people.
Good morning, Your Honor. Jacob Starks, Fourth Assistant Public Defender here on behalf of Mr. Jemison. Mr. Jemison appearing by Polycom from the lockup downstairs. Your Honor.
Thank you, Mr. Jemison. Can you hear me?
Yes.
Okay, thank you. Today's the date that was set for your preliminary examination. How are we proceeding on this?
Your Honor, my understanding is that at this time, both the people and the defendant are going to unconditionally waive their rights to preliminary examination and ask that this matter be bound over to the circuit court.
That's correct, Your Honor.
Is there an offer?
No. Not at this time. I anticipate Mr. Starks doing a fantastic job of negotiating upstairs.
Handle negotiations on the circuit court, Your Honor. Thank you.
Thank you. Mr. Jemison, do you understand that you have the statutory right to have a preliminary examination here in the district court?
Yes.
You understand that you have the right at the time of the preliminary examination to have the prosecution meet their burden of probable cause. So they have to establish that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crime. Do you understand that?
Yes, Your Honor.
Do you wish to unconditionally waive that right to examination today?
Yes.
Okay, so you understand unconditional means you can't come back later and decide that you want to have your exam. Once you waive it, that right is now gone. This matter will be sent to the circuit court for further prosecution. You understand that?
Yes.
Has there been any promises made to you to get you to want to waive your right to an examination?
No.
Anybody threatening you to get you to waive your exam?
No.
Are you waiving your examination freely and voluntarily?
Yes.
Yeah, I find your waiver to be made freely and voluntarily. I'll bind the matter over to the circuit court. Your bind over date's gonna be June 29th. That's the date that they're gonna get the file from this court. You do not need to appear in circuit court on that date, okay?
Okay,
You do not. Your next court date in circuit court will be a pretrial. Mr. Sarge will be made aware of that. He'll be in contact with you, okay, sir?
okay.
Bond was set at $100,000 cash surety. That will continue.
Your Honor, may I be heard on bonds?
Oh, you may.
Thank you. Respectfully, on behalf of Mr. Jemison, I would request a reduction in the current amount. The cash amount currently is $100,000. Mr. Jemison is an older gentleman. He has deep roots in the community. He's not a flight risk at all. While these charges are serious, Your Honor, concerns about safety and the welfare of the community can be addressed through the use of GPS tracking tethers, and also the supervision pretrial services is very thorough, and combined with the tracking device, the court will be aware of his location at all times. Further, Your Honor, Mr. Jemison has a very complicated situation with his medical care. He requires daily medications, and he's also recovering from some pretty serious injuries. I'm very concerned about the care that he's been receiving in the jail. He suffers from, among other things, respiratory ailments that require constant upkeep, and the conditions in the jail right now have been exacerbating his symptoms, especially as it relates to his respiratory concerns, among other things. So Mr. Jemison, due to his age, his health is a serious concern moving forward. If he gets released, then he would be in a better position to pursue his own medical care and make sure that he makes all his doctor's appointments and keeps up with his medications. He's had some struggle getting his medications while he's been in jail. And Your Honor, further, the process here up in circuit court, if we have to proceed to trial, is going to take quite a long time. I just finished up a trial in May that was from back in 2019, and scheduled to start another trial on Tuesday that also goes back to 2019. So my best guess, depending on the judge that Mr. Jemison would be assigned, it might take him 2 to 3 years to see a trial. If we have to proceed in that way, and Mr. Jemison is presumed innocent, yes, the charges are serious here, Your Honor, but respectfully, given his age, given his deep contacts to the community, including a fiance in the area, to keep track of his location, plus the use of GPS to other alternatives, I would just request a reduction of the current amount. Thank you.
I'm sorry, let me let you respond, but Mr. Jemison, are you born in 1973?
Yes,
Due to his age. What are you trying to say here?
Well, his age plus his medical issues, Your Honor.
Yeah, because I don't know that I don't know that 1973 is going to be a good basis for an age-related concern.
Well, his age plus his medical history.
Okay, medical history is a different situation, but
And
I'm not
medical
giving
history-
1973 any special consideration. Okay.
Your Honor, I would object to any reduction in bond. I think that given the allegations being very serious and the potential this is a life offense we're dealing with, if Mr. Jemison is found guilty, he's looking at straight prison time, nothing else. This is very serious. I think the bond that's been mentioned, $100,000 is adequate and sufficient and assessed appropriately. Mr. Jemison, while may be suffering from medical conditions, it looks like he's been in and out of prison since 1997. So since he was about 20 years old, including a stint in federal prison. He does have significant assaultive history as well. And in fact, the allegations here are that he went to the victim's home, confronted him at the door, and shot through their door to their residence. I think that a GPS tether in this instance, Your Honor, is just not sufficient. It's not going to be, it's not going to make my victim feel better. And it's definitely not going to make sure that he is not posing a risk to the community. And I'd ask that no reduction be made at this time.
Okay, we have count 1, assault with intent to murder. That's felony, maximum penalty being life for any number of years. There's a count 2, weapons, firearms discharge in or out of building, and a count 3 of weapons, firearms possession by felon. When Mr. Jemison was arraigned, obviously the arraigning official had copy of his criminal history to take into consideration. They're very serious charges. If the alleged charges are true, a GPS tether wouldn't be able to keep anybody safe because these kind of allegations present a concern for the public safety and for the safety of the alleged victim. So I think that the bond that's set in $100,000 cash surety is appropriate. And so I will deny any reduction at this time. You obviously can make a motion before the circuit court for a new bond.
Thank you, Your Honor.
Thank you. You're all set, Mr. Jameson, unless there's any other matters for the record.
Nothing from the people, sorry.
Nothing further from the bench, Your Honor. Thank you.
Thank you. This is Porter's. I have to highlight Jerome Porter. On the record of the matter of the people of the state of Michigan. I'm sorry, Jeremy Jerome Porter. File number 22-01314 FY, counsel appearance.
Morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. Jacob Starks, the Fourth Assistant Public Defender here on behalf of Mr. Porter. Mr. Porter is present in the courtroom. He's standing to my right.
This was a date that was set for preliminary examination. I have here a motion for Nolly stating that the necessary witnesses failed to appear. So this case will be dismissed without prejudice today. That means that without prejudice simply means that if the witnesses later make contact with the prosecution and want to proceed, they can reissue the charges against you. Do you understand that?
Yes.
Do you have any questions at this time?
No.
Okay, the case will be dismissed. It'll probably take about 72 hours before we can get anything out of lien as it relates to a no contact order. Are you on GPS tether?
Yes.
Okay, so that could be removed immediately. Any additional matters for the record?
Nothing from the people.
Nothing from the bench, Your Honor. Mr. Porter, I think you're going to have to go down to the county jail.
You are.
But it may take a little bit of time before they get to know. Okay. Thank you, Your Honor.
Thank you.
Yes, please. Yeah, thank you.
Neil Moore? Mr. Moore, Mr. Starks, do you think you can help him figure out what your office needs or why? he
Your Honor,
needs
I've been
something?
looking into that.
Oh, you did?
Yeah,
Okay.
he doesn't have a public defender in any of his files.
Oh, okay.
Our office needs proof of his loss of employment
Got
and
it.
income.
Sounds good.
That was communicated to him 2 o'clock yesterday afternoon. The information was he would email it as soon as possible.
Okay.
So as soon as he does that, that should clear up the issue.
Okay, he's mentioned before that he does receive public assistance by way of food stamps. Is that sufficient to provide your office?
The DHHS letter would probably be sufficient.
Okay, you can provide that information to them, sir, as soon as possible. They can re-review your file, so I can give you a new court date, so you can do that, okay? Okay, very good. I'll get you a new court date. We'll reset it for June 24th at 9:30, okay? That's next week, okay? We'll get you a copy of the notice if you sit tight, okay?
Oh, I could check, but tell for residents.
What else do you have?
Your Honor, I had the preliminary exam with Bryce Taylor, just waiting on Lacey to check on, see if there's any witnesses here.
Sounds good. Is that the same for you, Mr. Austin?
Hearing.
Sounds good. And Mr. White, same with you.
morning, Your Honor. We're here on Melman
You're planning on running?
on, yeah, we're planning on running, can I approach the prosecutor for a moment?
Are you on this one?
I'm not, Your Honor, but I can approach if it's,
Yeah.
unless you want to wait for, depending on, do you want to wait? For
No, that's
the answer?
fine. This is just the audio.
I can pretend to be Mrs.
Oh, no, it's right here. One moment. Okay, we're on the record in the matter of the people of the state of Michigan versus Matthew Carpenter, file number 22-01399FY. Council appearance.
Thank you, Your Honor. Good morning. Elish Gallagher on behalf of the people standing in for APA Crystal Murphy.
Good morning, Your Honor. May it please the court, Assistant Public Defender Steve Cornish on behalf of Mr. Carpenter is in the court standing to my right.
Thank you. Today was the date that was set for preliminary examination. And I think there's a motion for an adjournment.
Correct, Your Honor. Ms. Murphy is in a CSD first trial currently, and Judge Ocklina, and that's why I'm standing in to cover. When I was made aware of this exam, Your Honor, I immediately called the victim number that we had and left a voicemail. I had not heard back, but I also then did get a victim advocate to start actively reaching out. That victim advocate at around 8:50 this morning said she was actually able to get the victim on the phone and was able to relate to me that the victim said that she did not get her subpoena and was very visibly, I guess, not visibly, it was a phone call, but emotional over the phone. And I did check to confirm that we did send a mailer subpoena. We confirmed it was the right city. It's about, over an hour drive to here. I'm not able to know if the mailer was mailed appropriately timely wise, Your Honor. I don't have a return. That was just what I was presented with today. I did wish to request a 1-week adjournment. I understand this is a serious matter, and I apologize to the court for having to request this adjournment. And I believe that Mr. Cornish is asking for dismissal. The people do intend to reissue. We will do it today if the court would like to dismiss. Thank you, Your Honor.
That's correct, Your Honor. Today is the time and date set for preliminary examination. My client is here, his family is here to support him. We are prepared to proceed today, Judge. The victim was sent a subpoena by the prosecutor's office, which is their standard operating procedure. Never 100% certain if that's actually how you're supposed to subpoena people if they don't return the receipt on a certified mailer instead of personal service, is my understanding. But it seems very sketchy to me that she didn't get the subpoena when she leaves today. My understanding is she had been following along on the case, so we would be asking for dismissal.
Well, how would we know that she got, why would we be sketchy that she didn't get it? Have you not heard of anyone not getting mail recently? Like ever?
I have.
In the last year?
My understanding is that she was aware of what was going on in the case.
I don't know that. I don't know what she was aware of.
We don't know that she didn't get her subpoena.
Well, we know that she told the prosecutor.
She told the prosecutor.
Correct, and so
who hasn't?
It's not unreasonable to believe that someone didn't get any mail because, as the prosecutor indicated, she doesn't even know if or what the time frame was. It may still be en route. I know people have been waiting for mail for over 2 weeks at this point for it to go in the same city. So I can't speak to whether or not she received the subpoena or not. She did make communication with her. We know that. And it sounds like she is interested in proceeding in this case. I don't find it or believe that it would be meaningful or a good use of judicial resources to dismiss a case, for it to be reissued the same day, for us to reprocess it, to arraign him and reissue a new bond and paperwork of a bondsman needs to be reissued. That's not in the best interest of judicial economy, but for your client either. So I'm not going to grant the dismissal at this time. We'll reset it for 1 week.
Your Honor, would the court consider at least maybe removing the tether? We're hearing today that this complainant lives an hour plus away. She's not near my client.
You don't have a car?
I don't believe it.
So if it's an hour plus away, it means you can't get anywhere? Is that what you're alleging?
No, I'm alleging that it's not like he's going to run into her here in town. He's shown up to court both times, Your Honor. Got no issues whatsoever.
Okay. Ms. Gallagher.
I'm sorry, Aaron, I was getting confused because there was noise coming in from the gallery.
No problem. There's a request for removal of the GPS tether.
Thank you, Your Honor. I would request that for the next week, it be remain in place. And I understand respectfully that Mr. Cornish would be more entitled to then bring it up after the exam date next week. I have not obviously heard of any inappropriate contact. As I said, I had only learned through the victim advocate this morning when we first maintained contact. I should, for the record, Your Honor, put in that my office had never up to this morning been able to even get a hold of her. So I didn't want to misrepresent that. And I want that for the record as well. This is a CSE first case, Your Honor. And I do believe that tether is an appropriate way to keep the community safe and the victim safe in the interim of the preliminary examination hearing.
I just am wondering, what is the immediate threat to the alleged victim?
And I can't articulate that immediate threat, Your Honor, besides the obvious, I mean, I can't articulate through her words. I can articulate that this is a TSC first and that this victim was tearful this morning. I can't make representations about her, why she was emotional. If that had to do with her safety or if that had to do with just the court hearing coming up.
I can't either, but I don't have anything before me that would demonstrate that there has been a concern about the victim's safety, especially considering that it doesn't sound like the victim lives in the same city or area of Mr. Carpenter. But also,
I don't know where Mr. Carpenter lives, Your Honor. I'm sorry.
I have an address from here in Lansing.
Thank you.
Okay, I have an address from here in Lansing. The other thing is that since the time that he's been arraigned, that there's been nothing to indicate that there's been any violation. So I'm going to remove the GPS tether.
Thank you, Your Honor.
Thank you, Your Honor.
Let me get your new date. June 24th at 9:30.
Thank you, Judge.
Thank you,
No
Judge.
problem. We'll get you a copy of the notice. So you got it already? Okay. Do you have any questions today, sir? Okay. Any additional matters for the record?
No, thank you, Your Honor.
Do we need some sort of paper that you can take down to the jail to get that removed, or is the court just sent notice to?
He's gonna, I think we could probably send notice, but also let me double check what's going on here. I need to put on the record, I'm gonna find good cause to adjourn because it's beyond your 21 days. So sir, you have the right to have your preliminary examination within 21 days of your arraignment. You were arraigned on the 1st, so your new date for preliminary examination is a few days outside of that 21-day time frame. So because of whatever's going on with the subpoena of the alleged victim, I'm going to wait or find good cause to waive that 21-day timeline to set it to the date on the 24th, okay?
I actually have a question.
Yes.
Thank you, Your Honor.
No worries. That's a good idea. I think she knows what, or she'll know what the new date is. So she should be here next week. Any additional matters for the record?
No, thank you, Your Honor.
Thank you. You're all set.
I'm just Lacey for you, Your Honor.
Thank you. That was Is Mr. Carter here?
I came.
Mr. Palmer is here. I see Mr. Abbott. Nickel. What's going on with Ashton Clark?
Okay, yeah, that's fine.
Is Keith here?
I'm not.
Yeah.
Oh,
If you let,
White. My thing says it's Ashton Clark is represented by Keith. Yeah, you mean to tell me you're not printing my docket on the day of? You can't,
we don't do that.
you can't give me an old docket on the day. There you go. Okay, so Mr. White's here on Clark as well.
I'm not your honor.
It's Walter. I said Ashton Clark. You said who's here? Let me have your docket, please.
I think there's two different ways.
It's Walter
White.
Yeah.
Oh, yeah.
I'll give himself the updated.
I
document.
confuse myself, but they're two different ways.
There's a note here. I don't know what this note you have here, but it's not this white. It's what we got. Okay, what's going on? What are we doing here? Who's ready to go?
I can do mine, Judge.
Palmer's running?
Yeah.
We're not
And then-
running.
We're not running.
Not running?
Yeah.
No.
Okay, what about Jason Bike? Are we running that?
I do intend to run that, yeah.
What about Ralph? Is it Bahan?
That's how I-
Vaughn?
Your Honor, we
Not run
we
that.
were gonna waive, but there's no police officer here, so I'm gonna ask for dismissal.
I'll grab my.
Oh, it's only 8 minutes, so I would never get to dismissal in 8 minutes. You might want to sit tight. Yours was Gardner?
Yes, ma'am.
Okay,
And I think we're gonna mutually agree or ask for an adjournment. We'll put that on the record.
We're on the record of the matter, the people of the state of Michigan versus Sandra Gardner, file number 22-01110 FY. Council appearance.
Good morning, Your Honor. Andrew Lacy is hearing on behalf of the people.
And good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Ms. Sandra Gardner.
Thank you. Today was the date set for preliminary examination, and it looks like there's a stipulation to adjourn.
Yes, Your Honor. I reached out to Mr. Palmer he reached out to me because we're having a discovery issue. We were sent a discovery from the Lansing Police Department. That is bizarre. It's the only way to describe it. It's a bunch of screenshots and videos that don't pertain to the case. My office has reached out multiple times to get the correct evidence so that we can get it over Mr. Palmer. We don't have it. I have nothing that I can tell actually pertains to this case, and he has nothing which he can evaluate the case with his client because there was an offer made. So I'm gonna ask for an adjournment at this time because we are still trying to figure out the discovery issue.
Sounds good.
That's all an accurate statement, Your Honor. I've discussed this issue has been going on for a little while. I want to make clear, I don't believe in any way it's Ms. Lacy's fault. I think there's just some weird things going on in this file. I know we've been here before, and we've addressed this discovery issue before once. I did talk to Ms. Gardner about this and explained that we could potentially move for a dismissal today, or we could agree to an adjournment. I certainly believe that Ms. Lacy would reissue immediately if I asked for dismissal anyway. And so just in the interest of, I guess, judicial economy and not having my client arrested again or something like that, we've agreed to, we're stipulating to an adjournment. At this point, I don't even know how long to ask because we've been dealing with the issue for roughly a month and neither of us can figure it out. So I don't know whether we need another 2 weeks. I don't know whether we need, I just don't even have any idea.
That's correct. Our office first reached out to Lansing PD a month ago. And we have not gotten we haven't gotten a response and we have not gotten any, it hasn't been fixed. So I don't know how long it would take either. I know that it has been forwarded to the detective to deal with, but that's as far as I've got with that.
I guess the only other thing I'll say, Judge, is I do intend, if we can't get this figured out by the next day, I will be moving for business.
Sounds good. I will give you 2 weeks. We can do July 7th at 9 a.m.
I'm sorry, could I either go a week earlier or a week later? I'm actually out the week of July 7th.
We'll go a week later. We can do July 15th at 8:30.
I'll take it.
Okay, any additional matters for the record?
No, Your Honor.
Thank you. We'll see you at your next court date. Okay, ma'am?
Thank you,
Get
Judge.
your copy of that notice to appear. Okay. Molly and Bryce. And you said you do have the witnesses on bike?
It's gonna be like tomorrow.
And Ashton Clark is here with his attorney? Okay, you all are both here. Are we running that?
Clark retained a new attorney yesterday. I'm supposed to be looking into getting him a misdemeanor offer, but I told him that I could not figure that out this morning due to my docket. I would ask for an adjournment so that we could work out a potential offer if he was agreeable to that. It does appear that that would be agreeable to my officers.
We're on the record in the matter, the people of the state of Michigan versus Ashton Clark, file number 22-01435. Counsel, please.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Walter White, P 27792 on behalf of Mr. Clark. The prosecutor's recitation is correct. I had actually filed an appearance, but the court didn't get it. I filed it by email. I again filed it and called yesterday. I hadn't gotten discovery. I am trying to resolve it. I'd like to adjourn the prelim. I will indicate for the record that I'm willing to have the people have their witnesses on call rather than present on an adjourned day.
Okay. And have you had a discussion with your client already about his right to have his exam within 21 days?
Yes, we have.
Okay. Okay, so you understand, sir, that you have the right to have exam within 21 days? I'm sorry, I couldn't hear you. Okay, and you wish to waive your right to have that exam so we can reset this and your attorney can get discovery and further negotiate with the prosecutor? Okay. Anybody promising you anything or threatening you to wait the 21 days? Okay. Also, I have a bond violation notice here. When you were arraigned, you were supposed to, or you were told that you need to make contact with pretrial services. Did you do that?
Yes, ma'am.
When did you do that?
Yes, ma'am.
Because I got this on the 15th.
Your Honor, I would just indicate that I received it yesterday. I contacted him yesterday and he contacted pretrial services.
Okay, thank you. I'll dismiss the PA 53 violation. Make sure you're meeting or contacting them weekly. Okay, sir?
Yes.
Okay, and I will get you a new court date. Will be July 7th. Does that work for you, July 7th at 9 a.m.?
I can just check. I believe that will work.
Okay. Any additional matters for the record?
Nothing for the people, Your Honor.
And nothing for defense. Thank you, Your Honor.
No problem. We'll get you a copy, sir, of your new court date. On the record in the matter, the people of the state of Michigan versus Bryce James Taylor, file number 22-01131FY. Counsel appearance.
Morning, Your Honor. Andrea Lacy is hearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Bryce Taylor, who is standing to my right.
Okay, Mr. Taylor, today was the date that was set for preliminary examination. I heard that people do not have the necessary witnesses. Oh, actually, it didn't say. When this is being dismissed.
The necessary witnesses have not appeared, Your Honor, so we aren't able to proceed at this time.
Okay. Can you redo that with the reason, please? So this matter will be dismissed without prejudice, okay, sir? So that means that if the necessary witnesses later make communication with the prosecution and they're ready to proceed, they can reissue the charge against you and you could have to repost bond. Do you understand that?
Yes, sir.
Do you have any questions? Okay. Any additional matters for the record?
Nothing for the people.
None for defense, thank you.
Thank you. We'll get you a copy of that in just a moment, okay? You're welcome. Okay, folks, 9:47, we'll see if the witnesses. Where's Mr. Carter and Adrika?
The notes that I have, Your Honor, indicate that she was in a mental health facility last time, so she did get a bench for it. I don't know where Mr. Carter is.
It says that she was released from the hospital. Well, search warrant, please.
Sorry.
She was released. My note says she was arraigned on the 8th and released, so they're not here. I'm gonna bench warrant her.
Yeah, I don't. Yeah.
Not here.
And he never responded to that.
On the record in the matter, the people of the state of Michigan versus Ralph Bond, file number 22-01042, council appearance.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor, Toby White. On behalf of Mr. Collins, his name, I never quite pronounced right, but he's standing with me at council table.
I don't think I did it right either. What's your last name, sir?
Bond.
You said Blonde?
Yeah.
Oh, Bond. Okay, today's the date that was set for preliminary examination. My understanding is that the necessary witnesses, which is an officer, failed to appear.
For the record, Your Honor, there was one witness who I anticipated running the exam with who was supposed to be here, and then there's one who I got notice that he was on vacation. So I don't think it'll be an issue going forward because that officer is always here when I ask him to be here when he's not on vacation. So I do anticipate filing as well.
Okay. How do you want to proceed?
Move for dismissal.
I will grant you a dismissal without prejudice.
Thank you, Your Honor.
We'll get you a copy, okay?
Thank you.
You're welcome.
Have a seat and bring your account.
Are we running Archer?
I can. I don't know. I haven't had a chance to speak to Mr. Rich. That's gonna happen.
Oh, well, he probably should go first because this is at 9. I haven't seen Abbott or Nick. I see Nickel.
Yeah.
I don't know what we're doing with McCullough.
I don't know that either. I know there's a global revolution going on, but they did not let me know.
And so I have, by Archer, McCullough.
See if I can find Mr. Nichols. He might be standing in for Mr. Abbott if it's gonna be resolved.
On the record in the matter, the people of the state of Michigan versus Jason Bike. File number 22-01157, FY, council appearance.
Good morning, Your Honor. Andrea Lisa hearing on behalf of the people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Pike. He's present, standing to my right.
Thank you. Today was the date that was set for preliminary examination. We have a Nolly here. I'm assuming the necessary witnesses did not appear.
Your Honor, and I was intending to run this victim list, and I will submit and not acknowledge the first time writing one up right now, but I was intending to run this victim list. However, after speaking to the officer who responded to the scene, we are unable to substantiate the claim under the statute, so I'm not going to be able to go forward at this time.
Okay, so people are moving to dismiss this without prejudice. That simply means if they later do have the ability to proceed, they can reissue the charge against you. Okay, sir? Do you have any questions? Okay, I'll sign the dismissal. You'll get a copy in just a moment, okay? Any additional matters for the record?
Nothing further on behalf of Mr. Pike, Your Honor. Thank you.
Nothing at this time.
Thank you, sir. You can have a seat. I'm sorry? Don't do this on this Juneteenth weekend, okay, sir? We're not doing that to each other. We're not doing that, okay? All right, have a good one. Who? Mr. Carter? Where is he? Okay, sounds good. Hi, Ms. Blackman, how are you? You're good right there. You don't have to come up. Your attorney is not here. He's actually in trial. So we're gonna reset this, okay? We can do July 15th at 9:30. We're gonna set it for July 15th at 9:30. However, if Mr. Carter is not available, he'll email us and let us know. So we'll have to send you a new date, okay? Okay, thanks. No problem. We'll get you a copy of your note. You can have a seat there. We'll give you a copy, okay? Thank you. Thank you. July 15th at 9:30. No problem. Okay, let's see what else we got. So what are we doing with McCullough?
That. But we're working on a global resolution for him. So
okay,
either a German or something.
Archer.
Ultimately.
Is Archer here?
Yes.
Is Mr. Petrovich here?
Yeah, he is. I don't know.
Oh, McCullough, not sure what color, yeah. Hi, sir. Are you Archer?
Yeah.
Okay. Just waiting for your turn. Okay, we're on the record in the matter of the people of the state of Michigan versus Jose Archer, file number 22-01461 FY. Council appearance.
Morning, Your Honor. Andrew Lacy appearing on behalf of the people.
And Charlie Petrovich on behalf of Mr. Archer is present to my right.
Thank you. And today's the date that was set for preliminary examination. My understanding is that the people are unable to proceed. Is that correct?
Yes, Your Honor. The people are unable to proceed at this time. The necessary witness did not appear. The officer that I have here also that I could have run the exam with would not be able to substantiate the claim based on one call that was made. So without her participation, I'm not comfortable going forward at this time, Your Honor. This is my understanding. This is the first instance of any domestic violence interaction between the two of them. So I'm going to move to this.
Okay, so this matter will be dismissed without prejudice. Do you understand that, sir? It simply means the without prejudice part is that if the prosecution leader does have the ability to proceed, they do have the right to reissue the charge against you. Do you understand that? Okay. You should wait about 72 hours before any no contact order is removed from lien. Okay, you're not on GPS tether. Any additional matters for the record?
Nothing for the people.
Thank you. If you wait a couple minutes, we'll get you a copy of the dismissal. Okay, sir? What brings you here?
Thought we were gonna run a preliminary exam.
Well, you've been having a really good day so far.
You don't wanna run a preliminary exam?
So, I don't know.
No, it's just Corey McCullough, Your Honor.
Oh, okay, sounds good. I think I'm waiting for him to put him on.
No, that's okay. I'm healed up now, so we can have something I would do. Yeah, I ate it on that corner over there, right in front of the Michigan Senate building, and some guy yells after me. Good. I'm good. Good.
Pro forma,
Good.
they've authorized, they've submitted at least one petition against this case.
That was,
Got your
them-
letter.
they didn't know the name. They said you asked them to bring them up. That was them calling.
I said she'll take McCullough on Zoom.
Yeah, they said, who do you want brought up? And I said McCullough, so they said he's online. That's fine. If they're bringing him, that's fine. You can be seated. I didn't remember the name, so. You know. Giving us a little button action today.
Oh my God.
All right, we're on the record in the matter of the people of the state of Michigan versus Corey James McCullough, file numbers 20-0053, 523 and 21-01596 FY. Council appearances.
Morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Assistant Public Defender Scott Nickel on behalf of Mr. McCullough in file 211596 FY.
Good morning, Your Honor. John Abbott representing Corey McCullough on 20523 FY.
Thank you. Today was the date set for preliminary examination. When we were here before, I think we were waiting for him to be screened. We're proceeding at this time.
And I would defer to defense counsel. They have had discussions with the circuit court attorney with one of his other matters. I have a representation of the offer, but it's not my office.
So I have been in discussions with Nicole Matusco from the prosecutor's office, who kind of supervises these various treatment courts. And it's my understanding that Mr. McCullough has been screened for and accepted into 54B's drug court. There is a global offer where Mr. McCullough would plead to, I believe it would be the meth possession case in 211596 FY. Agree to restitution on all files, balance would be dismissed, and then he would be placed into the sobriety court. What we're waiting on is the prosecutor's office to get all of the transfer paperwork prepared, and so that both of these cases and the cases that are in 55th can be transferred over to 54B for plea and sentence.
I think we just did a 54B and they sent it back maybe once or twice because they wanted us to take the plea and sentence and then send it. So we'll clarify that this time too, because
Yes, we can
they
clarify
sent it
that.
back. They wanted their own form. They wanted us to do the plea and sentence and just have them monitor. So if that's the case, because I think I just signed the order today. So that we don't have anything coming back again.
And I think ultimately we're fine with doing it whatever way, but I prefer it be done in a way that once it gets over there, it stays and Mr. McCullough can complete that program.
Okay, Mr. McCullough, did you hear everything your attorney said about how these matters are moving at this time?
Yes, ma'am.
Okay, and that's your understanding of how you would like to proceed at this time?
Yes, ma'am.
Okay, so I'm going to give you dates so we can wait to get the paperwork. I'm gonna do a couple of weeks just because that paperwork has been taking a couple of weeks. I can set it as a plea. I'll set it as a plea versus an exam.
That would be fine.
That works for me.
July 8th, yeah. Does July 8th work? That was July 8:30, July 8th at 8:30. Okay, any additional matters for the record?
Nothing for the people.
Your Honor, if I could address Mr. McCullough's bond on the matter. My understanding at this point, his bond has been denied in this file. I would request on Mr. McCullough's behalf that a bond be set. He has been waiting for the resolution of this case for a little bit since he was arraigned. It is coming to fruition, but he would like the opportunity to be a trustee at the jail, and he cannot do that while he has no bond holds on him, which he does have. According to the jail records, he has no bond holds in both this file and the file Mr. Abbott represents. So I would ask the court to consider setting bonds in both files.
Okay. So he did have bonds, had pretty good ones. They never came to court. Like ever.
Yeah, I did. I came a couple times.
And I am aware of Mr. McCullough's history. That's why I'm not asking for the court to set personal or cognizant bonds. I think bonds of the nature of, $15,000 or $20,000 cash surety bonds would allow him to at least be a trustee.
Okay, he had 5,000 10% bond in file number 21-01596 previously. I'll issue bond on that file in the matter of 5,000 cash surety. And the bond in the other matter to the 20-00523 was previously set at $1,000 cash surety. Might add a couple of bonds. Looks like it started off as a PR bond, then it went to cash surety. I'll issue $1,000 cash surety bond on this one as well. Any additional matters for the record?
Nothing for the people.
Nothing for the defense.
No, thank you, Your Honor.
Okay, you're all set for today, Mr. McCullough.
Right.